Hi, thank you for watching my channel. Today I'm going to shed some light on seat and venue dispute in arbitration, which has always been a bone of contention and cause of innumerable litigation between parties. I've been assisted in the research for this subject by Antara Paral and Chaitanya Singh, both interns and doing a fabulous job with me. Before further deliberations, let me discuss a bit about arbitration. Arbitration is a private system of settlement of a dispute. Parties who want to resolve their dispute in a quasi-judicial manner go for arbitration. Basically, the term arbitration can be defined as the settlement of a dispute between the contracting parties in a speedy manner by the decision of the arbitrators and avoiding the lengthy process of litigation of the court. There are two forms of arbitration, that is ad hoc and institutional arbitration. Both forms have separate procedure for the appointment of arbitrators. In ad hoc arbitration, the parties select their own arbitrators and for applicable law, designation of rules, procedure and administrative support. However, in an institutional arbitration, the process is as per the institutional rules on the basis of payment of administrative fees paid by the parties. The institution may also allow the parties to select the arbitrators from the institution's panel of arbitrators comprising experts from various parts of the world. Now, in arbitration law, seat of arbitration is of paramount importance. The arbitral seat is the legal or juridical home of the arbitration, and therefore the choice of seat results in a number of significant legal consequences. It is important to understand the difference between the term venue and seat as agreed under the contract between parties. Now, the distinction between venue and seat may be read as that the seat of arbitration is what determines the court having jurisdiction over the nullity claim of an award, while the venue is the physical location where the arbitration hearings or deliberations are held. Now, the Supreme Court held in a lot of matters that the seat of arbitration is of vital aspect in any arbitration proceeding. Now, significance of seat of arbitration is that it determines the applicable law when deciding the arbitration proceedings and arbitration procedure as well as judicial review over the arbitration award. Now, in many cases, Supreme Court has held that the location of seat will determine the courts that will have exclusive jurisdiction to oversee the arbitration proceedings. Now, in many cases, it was held that seat normally carries with it the choice of that country's arbitral or curial award, and it is well settled that seat of arbitration and venue of arbitration cannot be used interchangeably. Supreme Court in a very recent judgment also held that the mere designation of venue of arbitration would confer exclusive jurisdiction on the High Court having jurisdiction over that venue to supervise the arbitration. Now, accordingly, the Supreme Court made the distinction between the seat of arbitration and venue of arbitration, amply clearly deciding upon this crucial aspect and to determine the applicable law when the arbitration proceedings and arbitration procedure are to be decided as far as dispute between the parties are concerned. Now, there are very recent three cases which have formed the crux of trying to sort out this dispute between them. One, of course, is Union of India versus Hardy Exploration and Production. I think Hardy has been a hugely important case as far as that goes, because the Supreme Court held that the parties had not chosen the seat of arbitration, and the arbitral tribunal had also not determined the seat of arbitration. So it was primarily about choice of Kuala Lumpur as the venue of arbitration did not necessarily imply that Kuala Lumpur had become the seat of arbitration. So as per Supreme Court, the venue could not by itself assume the status of the seat, and instead a venue could become the seat only if something else is added to it as a concomitant. Now, the Supreme Court therefore also held that Indian courts had jurisdiction to hear a challenge to the award which was granted in the Kuala Lumpur. Through this decision, the Supreme Court ultimately did not provide any clarity on this issue except the simple conclusion that a chosen venue could not be treated as the seat of arbitration in the absence of additional factors indicating that such chosen venue was intended to be the seat of arbitration. Now, then the other important case is Soma JV versus NHPC Limited. Last year in December, the Supreme Court revisited this issue, which concerned an arbitration agreement stipulating that arbitration proceedings shall be held at New Delhi or Faridabad, India. And the Supreme Court prescribed the bright line test for determining whether a chosen venue could be treated as the seat of arbitration. Now, this basically meant that if a named place is identified in the arbitration agreement as the venue of arbitration proceedings, the use of the expression arbitration proceedings signifies that the entire arbitration proceeding, that is including the making of the award, is to be conducted at such a place. As opposed to certain hearings, in such a case, the choice of venue is actually a choice of the seat of arbitration. Now, in contrast, if the arbitration agreement contains language such as tribunals are to meet or have witnesses, experts of the parties at a particular venue, this suggests that only hearings are to be conducted at such venue. In this case, with other factors remaining consistent, the chosen venue cannot be treated as the seat of arbitration. Now, if the arbitration agreement provides that the arbitration proceedings shall be held at a particular venue, then that indicates that arbitration proceedings would be anchored at such venue, and therefore the choice of venue is also a choice of the seat of arbitration. The above tests remain subject to there being no other significant contrary indications which suggest that the named place would be merely the venue for certain proceedings and not the seat of arbitration. Now, in the context of international arbitration, the choice of a supranational body of rules to govern the arbitration, for example, let's say the ICC rules, would further indicate that the chosen venue is actually the seat of arbitration. So therefore, the choice of Indian Arbitration Act would provide such indication, and the bright line test prescribed in Soma JV was diametrically opposite to that laid down in Hardy Exploration, while Hardy Exploration stipulated that a chosen venue could not by itself assume the status of seat of arbitration in the absence of additional indicia. Soma JV prescribed that a chosen venue for arbitration proceedings would become the seat of arbitration in the absence of any significant contrary indicia. Now, in case of Soma JV, the Supreme Court accepted the Shashwa principle, a principle that had first been articulated in the specific context of London arbitration. It may be noted that Supreme Court in Soma JV also held that its earlier decision of Hardy Exploration was per inquirum, and since it failed to follow the said principle, and the 5 judges bench in Bharat Aluminium which laid down. As a result, it appeared that Hardy Exploration was no longer good law and Soma JV would hold the field instead. However, there is still a lot of contradiction in terms of the application of the said judgments. Now, the other important matter was air visual, where Mankastu versus air visual, where in Mankastu it was relied on the judgment of Hardy. This was a very recent judgment of this year, but air visual relied on the judgment of Soma JV. Now that dispute actually kind of became very important, and Supreme Court, instead of decisively settling the controversy by affirming to Soma JV, kind of sidestepped it, and it said that the use of expression place of arbitration could not decide the intention of the parties to designate that place as a seat of arbitration, and such intention had to be determined from other clauses in the agreement between the parties and their conduct. So Supreme Court held that the choice of Hong Kong as the place of arbitration itself did not lead to the conclusion that the parties had chosen Hong Kong as the seat of arbitration. However, because the parties had also agreed that such arbitration was to be administered in Hong Kong, the Supreme Court ultimately held that the parties had chosen Hong Kong as the seat of arbitration. Now, as a result, if you see, it is unclear whether hardy exploration remains a good law, or bright line test in SOMA JV holds the field. Now, the bright line test laid down in SOMA JV is certainly clearer, more objective, and you can say it is aligned with the principle of party autonomy. However, it merits consideration and affirmation by Supreme Court whenever next opportunity arises. And in the meantime, parties would be well advised to use express language referring to the seat of arbitration specifically to avoid unnecessary litigation on this issue. On that note, thank you so much for watching my video today. If you have any specific queries with respect to the citations, or any query with respect to the dispute on the definition of seat or venue, do feel free to write into me. You can always leave a message here. Do like my video and subscribe to my channel and share it as much as possible. And do give me advices on the topics that I may make videos on. Thank you so much for watching, and have a nice week.